Welcome to the Deep Dive. Today, we're looking at something that sounds, well, frankly, a bit dry, an administrative change. But trust me, this one's actually causing a pretty big stir in India's legal world.
It really is. It seems small on the surface, but the implications are quite significant.
Okay, so let's unpack this. We're talking about the Department of Posts. On July 2nd, 2025, they put out this directive.
That's right, and it announced a merger between registered posts and speed post services.
The big headline being, registered post is, well, finished, gone, discontinued from September 1st, 2025.
Exactly, and the reason given, it's about efficiency, basically. They reported a big drop, something like 25%, in registered mail use over the last decade or so.
Right, between 2011 and 2019, people using email, couriers. Makes sense on one level. Modernization.
It does seem logical from that perspective, but what's fascinating, or maybe concerning, is the legal side. While the Post Office Act, the 2023 one, seems to give them the power to do this sudden move, it kind of pulls the rug out from under some really specific legal ideas, particularly this concept of deemed service.
Deemed service. Explain that for you listening. What exactly is that?
It's a legal shortcut, essentially. It means if you send a letter via registered post to the correct address, the law presumes it's been delivered, served, whether the recipient actually signed for it or not, sometimes.
Ah, okay. So the act of sending it correctly by registered post was enough legally.
In many situations, yes. It created a presumption, and now, poof, the service that presumption was built on is gone.
So here's where it gets really interesting, right? This specific law, Section 27 of the General Clauses Act, 1897, that's the linchpin.
Absolutely, that's the bedrock. Section 27 explicitly provides this safety net. Send it registered post, properly addressed, prepaid, and service is considered done unless someone proves it wasn't.
And courts have relied on this.
Heavily, for decades. The Supreme Court has repeatedly upheld this. You have cases like Ms. Madan & Co., Gujarat Electricity Board. Even if the letter was refused, the court often said, well, service was affected.
Wow, even refusal didn't necessarily stop it.
Correct. And in another case, CCL v. Haji, the court basically said you don't even need to plead anything further about delivery once you show it was sent by registered post. It's deemed served. Full stop.
And proving otherwise is hard.
Very hard. The standard is incredibly high. You need evidence of impeccable character, as one ruling put it. And, the legal basis for this idea, it's still there in the new evidence law, the Haratya Sakshatibhyam.
And you mentioned the timing. The Supreme Court just talked about this again.
Almost unbelievable timing. Just 2 weeks after the Department of Post decision, July 16th, 2025, the Supreme Court, in the Krishna Swarup Agarwal case, reiterated this exact principle of deemed service via registered post.
Okay, so the courts are still operating on this principle, while the administrative branch just removed the mechanism.
Precisely. It creates a real disconnect.
And does this mess impact other specific laws? Beyond the General Clauses Act, what about, say, the Code of Civil Procedure, the CPC?
Oh, definitely. Take Section 148A of the CPC. It deals with caveats, when someone wants to ensure they're heard before a court issues an order.
Right.
That section explicitly says the person filing the caveat shall serve a notice by registered post acknowledgement due. Shall, not may, not speed post, registered post AD.
So now what? Does shall become may? Does registered post mean speed post? The law hasn't changed, but the service it mandates, it doesn't exist anymore.
Exactly. It creates ambiguity where the law intended certainty. And yes, other parts of the CPC, like Order v. Rule 9, do allow for speed post or couriers for serving summons.
Okay.
But even that rule has a proviso, a little add-on, that specifically mentions the presumption still applies if you use registered post.
Yep.
So the law itself acknowledges the special status of registered post for proving service.
Huh. So it's woven pretty deeply into the legal fabric, and not just at the union or federal level, right? What about state laws?
That's another huge area of concern. This raises a really important question. Many states have their own General Clauses Acts, often with sections that mirror the union's Section 27.
Like Maharashtra.
Yes, for instance, Section 28 of the Maharashtra General Clauses Act, and then you have specific state laws, like Section 43 of the Maharashtra Rent Control Act. It specifically creates a presumption of service for summons sent by registered post.
So this single administrative decision by the Central Department of Posts could potentially invalidate or complicate sections in numerous state laws across the country.
That's the fear. It makes you wonder, were the states even consulted? Were these knock-on effects considered? It seems unlikely, given how abrupt it was.
So wrapping this up, what does this all mean for you, the listener? It really highlights this tension, doesn't it?
It does. On one hand, you have the clear need to modernize, to adapt to how people communicate now, digital, faster services. That makes sense.
But on the other hand,
On the other hand, you have these sudden changes that cause, well, unintended chaos in a system built on long-standing procedures, especially procedures tied to fundamental legal principles like ensuring someone has been properly notified.
it feels like maybe a more gradual approach. Phase it out. Give lawmakers time to amend all these different acts.
That would certainly seem prudent. A phased approach would have allowed Parliament and state legislatures to update Section 27, Section 148A, the state equivalents, all those related provisions. It could have avoided this legal predicament we're seeing now.
So the takeaway isn't that modernization is bad, but maybe how it's done matters enormously.
Absolutely. It's a reminder, really, for all of us how a seemingly small bureaucratic tweak can send ripples, sometimes quite large ripples, through the entire legal system. Something to think about.